Major breaking news. We had a huge oral argument. In fact, two oral arguments today in front of the United States Supreme Court for the Ninth Circuit out there in San Francisco. Specifically, we had three cases argued: Carolello, May, and Wolford. These were cases were brought involving California's quote-unquote sensitive places law, which is a euphemism for government-mandated gun-free zones, meaning that even if you have a concealed carry license and you've gone through all the hoops to get one in California, you're still not allowed to carry guns in these particular places. These are all part of the anti-Bruin decisions by states like California. The cases that we're going to discuss today in this major oral argument involve those brought effectively by the Firearms Policy Coalition, the Second Amendment Foundation, the California Rifle and Pistol Association, the Gun Owners of America, and the Hawaii Firearms Coalition. So let's talk about these cases of Carolello, May, and Wolford when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many books, including Disarm What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, major oral arguments today before the United States Court of Appeals for the Ninth Circuit in San Francisco involving California's quote-unquote sensitive places laws that basically are government-mandated gun-free zone laws. Almost all of these, if not all of these, are entirely unconstitutional under the Bruin methodology. Just to remind you, the way the Bruin methodology, which is really the Heller methodology, made in sippy cup ease to understand in the Bruin case by the U.S. Supreme Court. You start with the text of the Second Amendment. Once the modern-day gun control law implicates the text of the Second Amendment, very easy to satisfy that standard. The burden shifts to the government, and basically the courts have to ask the government, what historical analog laws do you have to prove that the law that you're trying to uphold today in modern-day America is a long-standing, well-representative, well-established, well-understood law at the time of the founding. And when you're dealing with government-mandated gun-free zones, that's really very hard for the government to do because the right to keep and bear arms obviously allows for you to carry guns in public. That's what the Bruin case expressly stated. And of course, what California has done after Bruin is they try to label all these places government-mandated gun-free zones. Now, the first two cases, Carolello and May, were cases that Judge Cormac Carney basically ruled against California in all respects. The quote-unquote sensitive places that he declared to be unconstitutional under the Second Amendment because there's simply no historical analog laws. Remember, it's not just a few laws. You can't just have pinprick history to justify a modern-day gun control law. It has to be extremely well established and well understood in the law. It can't just be, again, a few outliers. That is just insufficient, as the Supreme Court has repeatedly said. Now, the sensitive place issues in the Carolello and the May case involve gun bans on hospitals, mental health facilities, nursing homes, medical offices, urgent care facilities, other places where medical services are provided, public transportation, establishments where they sell liquor, even if you're not drinking liquor. That means every Greek diner, for example, in New York City, you wouldn't be able to bring a gun in because most of them have liquor licenses. But of course, we're talking about California in this particular case. Anything involving public gatherings, special events, playgrounds, private youth centers, parks and athletic facilities, the Department of Parks and Recreation, casinos, gambling, wildlife areas, except if you're going to go hunting, stadiums, arenas, public libraries, amusement parks, zoos, museums, churches, synagogues, mosques, and other places of worship, financial institutions, which would be banks, and they have the so-called vampire law. Just for those of you unfamiliar, the vampire law, I tend to call it the default rule. Basically, the way the vampire law works, and just to jog your memory, the lore or the myth of vampires is vampires are not allowed into your home unless they are invited in. So the metaphor of the vampire law dealing with concealed carry and government-mandated gun-free zones works this way, that you're not allowed to bring a gun into like a gas station or a restaurant or any place, a business that's open to the public without the express permission, either by virtue of a posting of a sign or otherwise, that the owner of that facility has given you consent to bring your gun in. And if you don't get express permission to bring your gun into like that random gas station on the side of the highway or that random rest area on the side of the highway, then you're not allowed to bring the gun in. Now, the the United States Court of Appeals for the Second Circuit and all the other courts so far have rejected the vampire rule as being absurd because because that'd be like saying, like, you can't come in here if you're a Trump supporter without my permission. That's not how constitutional laws work. So anyway, that is also on the table in the Carolero and the May case. And the other case argued today was the Hawaii Firearms Coalition's case of Wolford. That involves various places, including parking areas adjacent to buildings or offices owned by the state or county, restaurants serving alcohol in their parking lots next door to them, beaches and parks and banks and a bunch of other similar places to California. So anyway, the problem is with today's panel was three problematic judges, in my opinion. It was Judge Schrader, Judge Graber, and Judge Sung. Graber is a long-standing anti-gun, undeniably anti-gun judge, a senior Clinton appointee. She's ruled against Bruin and Heller and gun rights in all respects in every case she's ever touched out there in California. So I suspect Judge Graber is going to be hard to win. Judge Schroeder here is a senior Carter appointee. She's also upheld gun control laws in the past in California. And the one we have the most hope for, in theory, based on the arguments today, is Judge Sung, a Biden appointee. There doesn't appear to be any real Second Amendment record, but she is on the record signing a letter against Brett Kavanaugh when he was being elevated to the U.S. Supreme Court by the United States Senate. She signed a letter of Yale alum and faculty members that said they terribly opposed Brett Kavanaugh. As to the argument itself, it was clear that the Second Amendment lawyers have the best argument, but it's also clear to me that this, what I anticipate to be an anti-gun judge, I don't want to do double negatives there, so I better say anti-gun judges, we're going to lose. But I think we're going to lose the way I predict. Here's what I predicted before. I stand by that. The court was very interested in avoiding a circuit split with the Second Circuit. If you may recall, in the Antonyuk case, the United States Court of Appeals for the Second Circuit basically said that all the sensitive places designated as government-mandated gun-free zones by the state of New York were constitutional and fine, with the exception of the so-called vampire provision, which is you can't bring a gun into a private business establishment like a gas station off a highway without getting express permission. That was not allowed by Antonyuk. I think this Ninth Circuit panel is going to just follow Antonyuk. They're going to punt. They're going to be lazy. That's what I think is going to happen. They're just going to say, we agree with the Second Circuit Court of Appeals in all respects, and at this point, we want to avoid a circuit split. And why do you think the Ninth Circuit Court of Appeals wants to avoid the circuit split? In fact, I will tell you that in my career, I think it's very, I cannot recall another time where there was such a concern about creating a circuit split during an oral argument. Why do you think the Ninth Circuit wants to avoid a circuit split on sensitive places? It's because, of course, we've talked about this. One of the main reasons why the United States Supreme Court will take up a case in a particular subject matter is if there is a circuit split between different courts of appeals. So it's pretty clear to me the Ninth Circuit is going to want to avoid a circuit split, which is good for us in one sense. It's good for the Second Amendment because I think they're going to declare the California vampire provision that says you can't bring a gun in a gas station and whatnot without the express permission. I think they're going to agree to avoid the circuit split. So that will be at least a win out of this panel. But as to everything else, they're going to fallaciously conclude that everything that was designated specifically parks and whatnot are sensitive places, which is clearly wrong, 100% wrong. But let's talk about some other questions. In addition to being worried about the circuit split, there was this ridiculous question from the panel about, well, it says historical analog versus analogs. They tried to suggest that a single analog could justify the historical tradition of firearms regulation in the United States. That's clearly dumb because the Supreme Court has repeatedly said that outlier laws are not allowed. For example, in the Bruin case is specifically in talking about a territory of New Mexico. For example, it says that this extreme restriction is an outlier statute. It also goes on to say somewhere else in Bruin that the Texas statute and the rationale set forth in the English and Duke case are outliers. So the fact is that a single law obviously would be an outlier. I might have used the word outlier. If I was doing the oral argument, I would have said, well, Bruin specifically says you can't have outliers and a single law is not enough. And I might have quoted that. Nevertheless, I don't think that single argument, there's no way in a whole country a single law is going to give rise to a historical tradition of firearms regulation. And don't forget, in America, we actually don't have a historical tradition of firearms regulation. What we really have is a historical tradition of no or minimal firearms regulation. We're going to work on that more down the road, but for now, just keep that in mind. The next critical thing is there was a discussion by California and the court about historical silence. Remember how I've taught you before, this is extremely important to remember, that when the historical record is silent, meaning there is no examples of gun control laws on the books at the time of the founding, when the historical record is silent on a point, that means we win, because the historical record is never actually silent on the right to keep and bear arms, because the ultimate historical record, the most important, powerful, legal historical record in American life when it speaks to the right to keep and bear arms is the Second Amendment itself. In 1791, it is part of the Constitution. That is the historical record. The only way the government can overcome that is with a whole host of various laws that could show that there is understand that broad protected textual right of the right of the people to keep and bear arms can be overcome. And the example, again, I always like to give is, again, you cannot assert a Second Amendment rights in defense specifically to a cold-blooded murder case. It does not allow you to commit cold-blooded murder. That was understood all across the country. That's a sort of historical tradition of regulating guns that would be acceptable, but anything short of that as a general matter, no. But there's no doubt that California and this 3-judge panel of anti-gun judges, I'm sure they are, we'll see what happens, they're trying to say that historical silence is not enough, but that is clearly wrong. Historical silence always works in favor of the Second Amendment because the ultimate document that speaks to it and is not silent is the Second Amendment itself. Then, of course, the linchpin of the entire argument by California, all of it rides on their interpretation of a sentence in the Heller case in 2008. The Supreme Court in Heller says that schools and government buildings are presumptively, and this is the key word, and the lawyers for the Second Amendment I thought did a good job on this, that is presumptively sensitive. Presumptively sensitive. Well, we know from the presumption of innocence that presumptions can, yes, be overcome, right? You're presumed innocent, but you can still be found guilty if the government proves beyond a reasonable doubt you committed a crime. So presumptions can be rebutted. So the fact in Heller they say that schools and government buildings, in that case involving a handgun ban, just said in dicta that these places are presumptively sensitive, it doesn't mean it's true. You still have to do the analysis. And remember, Bruin narrowed the scope of what are sensitive places at the time of the founding. They did not mention schools. They did not mention government buildings. They narrowed it down to polling places, to courthouses and legislative chambers. And I thought the Second Amendment attorneys did a very powerful job pointing out that what makes the courthouse, and they specifically talked about the courthouse today, is objectively speaking, that there were metal detectors at the courthouse in San Francisco today. There were men with guns at the courthouse today in San Francisco. And that meant that the government had taken on the responsibility of protecting everyone in the building. And thus the need for self-defense in that building was dramatically lessened or eliminated because the government stepped up to protect them. And that point was made very well. And that explains exactly why a place is sensitive. It's that the government is completely protecting you. They cannot label it sensitive, and that's enough. Another powerful argument that the Second Amendment lawyers made against the court today, and I think they were really arguing against the court here, because it's pretty clear the court had made up its mind, as I predicted when I saw the list of 3 judges. They specifically talked about how at the time of the founding, where there was a place that was truly sensitive, like churches, at least metaphorically sensitive, guess what? The founding fathers told you to bring a gun. An example that the Second Amendment lawyer made, very powerful example, was churches. At the time of the founding, and I want you to step back and think about this very carefully, very important point. If you think about churches, at the time of the founding, and even today, by the way, but at the time of the founding, what do you do at church? First of all, it's a group of people that come together. So Americans had congregating together. Number 2 is they're praying. So in some ways, they're more vulnerable to being attacked because they're focused on their prayers and their worship. 3, there's a history of people attacking churches. Back in the day, it was the Native American Indian tribes, the merciless Indian savages, as that phrase was used in the Declaration of Independence, that would go on and attack people when they went to church. And last but not least, they are in that church doing what? They are exercising constitutional rights. Their constitutional right to worship, to free exercise of religion, and to free speech. So in this very place, this single example proves that when you have a group of people come together to exercise constitutional rights that may be vulnerable, what did the founding fathers insist upon? Not only allow and insist upon, but they never banned. That is bringing guns. Specifically, there are laws on the books at the time of the founding that you are required to bring guns to the church to protect that community. There is simply no example at the time of the founding of a gun ban in a church. So to me, that single example takes out the entire anti-gun arguments that says, well, you can ban guns and really what they're saying is we can ban guns wherever 2 or more people come together for any kind of activity. That's essentially what the position California is taking here. There's 2 other things I want to bring up. There's a confusion by one of the judges. You wonder if these people read these cases carefully, even though they're federal judges with lifetime appointments. They were trying to understand why, how, and this is absurd, but they're literally asking questions why the how and the why of laws matter for historical analogs. Well, maybe they should have read the Supreme Court's decision in Bruin, because tell me if you think this might have answered the question of the judge. This is what Bruin says, quote, "We do think that Heller and McDonald point toward at least 2 metrics, how and why. How and why the regulations burden a law-abiding citizen." Okay, so there you have it. Literally the words how and why, meaning the how and a why a historical analog existed on the books at the time of the founding, and how that can be used to draw an analogy to a modern day gun control law. The classic example we like to talk about here is the why you had gunpowder regulations at the time of the founding was because you were worried about fire, had nothing to do with crime or anything like that. So therefore, if you have a gunpowder regulation today involving, let's say, you can't have more than 10 rounds in a magazine, that's what the anti-gunners try to justify, using those gunpowder regulations at the time of the founding to justify a magazine limitation today. But the whys are different. The why of the black powder restriction was fire prevention. The why, presumably, of the magazine restriction is crime control. They're totally different. So there's other arguments made back and forth, but at the end of the day, I suspect, we're going to lose this case. They're going to embrace the Second Circuit's wrong decision. We'll talk more about sensitive places going forward. I thought the Second Amendment lawyers were very strong. I'll post some discussions of them in future videos. I think the judges are clearly going to rule against this because it's a terrible panel. And they're not going to take any of this stuff seriously. They're just going to punt and be lazy and basically pretend to follow the Second Circuit. But what they really want to do is just shut down all guns and embrace all gun control law. There's no way we're going to win this beyond. The best we can do, I think, is knock out this vampire rule, which is a very big deal to prevent people from banning guns wherever you go, just by virtue of there not being a sign that says guns are allowed. All right, folks, so that's it today here at the 4 Boxes Diner. Make sure you subscribe and resubscribe. Don't get knocked off the list. We're trying to get to 150,000 subscribers, working hard to get there. Don't forget to follow me on X at 4 Boxes Diner. We now have over 15,000 followers on X, so people are tracking the Second Amendment work I'm doing over there as well. And we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.